we'll just allow delegates to come into the meeting. Well, good afternoon, everyone, and welcome to this Class Legal and Financial Remedies Journal webinar on mediation advocacy. My name's Rhys Taylor. I'm a barrister at the 36 Group, and it is my pleasure this afternoon to host these leading practitioners in the realm of non-court dispute resolution to tell us something about mediation advocacy. You would have to have been marooned on a desert island not to know that mediation and non-court dispute resolution are on the march, and there have been amendments to both the civil procedure rules and the family procedure rules in the last year, encouraging and in some cases mandating the use of mediation and non-court dispute resolution. As it was with European law a couple of generations ago, it's flowing up into the estuaries and into the rivers, and it's affecting the way in which we manage our disputes and resolve our disputes. But in this brave new world, where does this leave the lawyers? And hopefully in this webinar, we'll have an opportunity to discuss the role of lawyers in the mediation process. I appreciate not everyone wants to be a mediator, but what is the lawyer's role in the mediation process? As I've already said, we have leading practitioners here this afternoon to talk us through this, both from the civil and commercial perspective and also from the family hybrid perspective. From where I'm sitting, I think there is much in common with the civil and commercial model and the hybrid model, and hopefully we'll be able to discuss some of that as well. This webinar is part one. We tried to see whether or not we could get everything down to an hour, and we just simply have failed to do so. So I'm able to say that part two of this webinar, which will deal with some of the more granular aspects of what goes on in a mediation so far as the lawyers are concerned, will take place on the 10th of June at 1 p.m. That's all I want to say by way of introduction, and I'm now going to ask the speakers to introduce one another. So over to the family lawyers first, please.
So I have great pleasure in introducing Suzanne Kingston. Suzanne and I are no strangers to doing webinars together. Suzanne is a consultant at Pennington's Manches Cooper in London and also Carey Olsen in Jersey. She is a long-standing member of Dispute Resolution Committee. She's a very well-regarded trainer, particularly in the area of arbitration, and I have the pleasure of providing hybrid mediation training alongside Suzanne, which we've now done for many years. She's a force to be reckoned with a client and contact base to be envied, and it's a pleasure to be appearing on this webinar with her this afternoon.
Karen, it's great to be working with you yet again. I love training and working with you. Karen Walker started her own firm in 2012, and it's been a huge success, both in terms of litigation and non-court dispute resolution. She's famed for both, so both carnivorous and vegetarian, as I like to say. Karen is an arbitrator, a mediator, hybrid mediator, collaborative practitioner, and does all of the above a great deal. And she's also very involved with the Worshipful Company of Arbitrators. Karen, great to see you again.
Andrew Goodman is a barrister and the leading trainer in mediation in the UK and possibly in the world. He travels everywhere all the time, which is why he's known as Air Miles Andy. He pretty much invented the concept of mediation advocacy. He wrote a book about it. I read it, I disagreed with it and wrote my own. That was 13 years ago. Since then, we have done workshops and made videos together. He describes us as friendly rivals. Well, at least one of those words is true. He also founded the SCMA, the Standing Conference for Mediation Advocates. What Andrew has to say is often original and sometimes provocative, but always worth listening to.
Thank you very much, Stephen. I'm sure most of you who are watching are well aware that Stephen Walker is one of the preeminent independent full-time mediators in the country. He's ranked in tier 1 in both Chambers and Legal 500, and justifiably so. Stephen's done well over 900 civil commercial mediations, about 250 online, more than 250 online. And he's a well-known and well-regarded author who extends his writing to cover areas such as digital work and the business of mediation generally, as well as assisting practitioners, both who wish to be mediators and who wish to appear in mediation. And as he rightly says, we have enjoyed working together, and I regard our friendship as extremely valuable because we bounce ideas off each other, which we can then share with the wider mediation world.
Thank you very much. I'd like to start with Stephen, if I may, and to ask Stephen to sketch out the essentials of civil and commercial mediation.
Well, good afternoon. So what's civil mediation like in 2025? Well, in some important ways, it's very different from what it was like in 25 or even 2020. First, two general points. We talk about civil and commercial mediation. There's a distinction drawn between commercial, which is about businesses and business, and the language of the discussion and negotiation and the outcomes is money, and civil mediation, which is more about individuals, emotions and relationships, and where there are more non-monetary outcomes. So contested probate, arguing about Auntie Mary's will, is civil. Arguing about your shareholding in a company is commercial. As you can imagine, the distinctions are blurred and they overlap. But is it important? Well, only in that the two wings of mediation, the resolvers who provide resolution and get down to the root causes of conflicts, and the problem solvers who just deal with the symptoms and merely provide solutions, sometimes have different approaches. And we could talk about that. But in the end, they're doing the same thing, mediation. So this is my second general point. What is mediation? And whether we like it or not, mediation is negotiation. Not every negotiation is a mediation, but every mediation is a negotiation. And that, I think, is what mediation is, assisted negotiation. Now, some will tell you it's more than that. It's about changing people's worldviews and empowering them to deal with life issues. That's the therapy wing of mediation, the resolvers. But in my experience, certainly in commercial mediation, people don't come to have their personalities remodeled and their values replaced. They come to get out of a mess through discussion, negotiation. And I want to suggest to you that a good definition of negotiation is the mutual recognition of reality, your own reality and the other side's reality. So we've got to get real. And advocates at a mediation, you are not there to make a case. You are there to make a deal. I think there's two things we need to grasp about mediation at the moment. One, it's growing, and two, it's changing. Growing. The number of mediations is growing. The 11th CEDA audit is out next week, so we'll get the up-to-date numbers. But over the last 10 audits, which are done every 2 years, the numbers have been steadily increasing. And the big change recently is, of course, mandatory mediation. it has been introduced for civil claims, for civil cases, the small claims under £10,000. Now, some argue that the 2-hour telephone conversation that the Ministry of Justice officials provide isn't really mediation. Well, we can talk about that as well. But the MOJ have said they're going to roll it out for fast track and multi-track, the bigger cases. And in my view, mandatory mediation is here to stay. It's part of the Master of the Rolls, Sir Geoffrey Voss's digital revolution for the civil justice system. He's repeatedly said, as has the MOJ, that mediation will be embedded in the English civil procedure system. As he says, it's no longer alternative, it's mainstream. And since last October, the courts have had the power to order people to go to mediation, even if they don't want to. Mediator is also changing, I think mainly for the better, and it's in two ways. Some of the established components of mediation are being bent out of shape or even abandoned. You remember the traditional definition. Mediation is a voluntary, confidential process where the parties to a dispute invite a neutral third party to help them find their own solution. Well, it's not really voluntary anymore. We've got mandatory mediation. And in commercial life, it's not been voluntary for a long time. Many contracts stipulated that you had to go to mediation before you went to litigation or arbitration, and the courts enforced those clauses. Confidential. Well, that confidentiality, both internal within the mediation and external, the outside world, are facing two big challenges. One from the courts, who say, if people wanting to order people to go to mediation, then we need to know what's going on. And so, in the interest of justice, as the courts say, they can compel mediators to come and give evidence, even if the mediation agreement says the opposite. And the second challenge is the tech. Recording devices are everywhere. And this is important for internal confidentiality. Smartphones, smartwatches, we'll have to be aware that confidentiality is not such a robust element of mediation as it used to be. And the third component is the use of the neutral. The definition was finding a neutral to help you find your own solution. This was called facilitative mediation. It's still the primary model. It's what mediators are trained on. But certainly in commercial mediations, there's a growing demand for a more proactive and directive approach, even evaluative. And Andrew Goodman knows all about that. But the second big change is online mediation. That came in through COVID and lockdown. Clients had to go online. They had no choice, and they found they liked it. It's cheaper. They save time, they save money, it's less stressful and intimidating, they can get on with their lives. And the process is more flexible. So in my view, online is the way forward. In the last CEDA survey, the February 2023 one, they concluded that 64% of commercial mediations were done online. And on an individual level, over the next 3 weeks, I've got 9 full-day mediations, 8 are online. There's never been a better time to get into civil and commercial mediation, either as an advocate or as a mediator, because as Geoffrey Voss says, it's now mainstream. Thank you.
Thank you very much, Stephen. So can I turn to Suzanne, please, to tell us a bit about hybrid mediation?
I want to talk about hybrid mediation, but before I do so, I just want to pick up on some points of similarity that I would like to draw between the comments made by Stephen and what we're going to develop and talk about today. I agree that in a family law context, mediation is growing. The main reason for that, and Karen is going to expand on this later, is on the 29th of April last year, there was a new practice direction and there are more cases going to mediation with cost implications potentially if you don't. So really interesting to discuss that. I would say that mediation has become more directive since I have been a mediator. The issues pertaining to confidentiality in civil and commercial and family mediation, hybrid mediation are the same. There is more use of neutrals. I've discovered that as going through mediations. And obviously we too have adapted online mediation. So there's lots of similarities in the themes of the civil commercial model and the hybrid model. But what is the hybrid model? The hybrid model is a hybrid, as the name suggests, between the family model remaining at the core of the mediation, but also adapting and using the civil commercial model. The main difference is that in the family model, the mediator is not able to hold confidences. But in the hybrid model, it is possible for the mediation to hold confidences, but only potentially for a very limited time and for a very limited purpose. And that's what we will be going on to discuss later, the sorts of circumstances in which the mediator may hold confidences. Often, and that's why we're talking about this today, the parties' lawyers are much more directly involved in a hybrid mediation than they would be in a typical family mediation. And we've got some top tips to discuss with the listeners today about why hybrid mediation is successful and how you as advocates may assist in a hybrid mediation. It may be that in a hybrid mediation, the meeting length is longer rather than the old typical way of family mediation being 1.5 hours to 2 hours per session. In a hybrid mediation, we would often see the mediation being a half a day, or even one I've done recently, a 4-day mediation. The mediator may directly involve other professionals in the process. Recently, I've had cases where I've involved accountants and trustees, IFAs. So the use of neutrals coming into the mediation process much more in a hybrid model than I suggest typically in a family model. So just by way of reminder, really quickly, the distinguishing feature for hybrid is the ability of the mediator to hold confidences, but also there are typically more use of lawyers, the meeting length may vary, and the mediator may involve other professionals.
Thank you, Suzanne. Andrew, I wonder whether you'd like to reflect at all from your perspective about some of the nuance between civil and commercial and hybrid mediation.
I think there are a number of core distinctions that we can look at immediately. The first being, of course, confidentiality. Both forms share distinctions of process management, but flexibility is such that these days one can talk to the mediator about what you want and what you don't want as a party representative. And process can be entirely flexible over the course of the entire period from the mediator being appointed to a settlement agreement being reached. But at the heart of civil, of course, is confidentiality. Confidentiality is pretty much everything because the parties are relying on trust in the way in which they engage in the mediator. I think that this idea that you speak to the mediator as a trusted ally, both before and during the course of the mediation, is essential for success in civil or commercial work. I think that another significant distinction is the degree to which the court can supervise not just the process, but the outcome. I'm very reluctant to have the court have anything to do with the outcome of civil commercial mediations. As far as I'm concerned, you are replacing court proceedings, you're replacing the dispute with the mediated outcome, and therefore the mediated outcome has got nothing to do with the court. And if a court action is running and you're putting in a Tomlin order to stay it, the order should simply be the stay, and the schedule attaching to the Tomlin order, which sets out the terms of the agreement, I think have really got nothing to do with the court. That being said, I do appreciate there are occasions when you have vulnerable parties for whom the court's protection is necessary, and that obviously sits nicely with comparing it with family work. I do think that as we move into periods of mandation, we're going to see a good deal of process merger. And I think that the idea that the court should become much more interested in what's going on is a direction of travel we're going to have to cope with. Although speaking as a mediator, it's not something I'm comfortable with. And of course, the other very significant difference is that the mediation in civil and commercial work need have nothing to do with the dispute. Invariably, you're looking for options for mutual gain in respect of the client, and that doesn't tie you to the legal cause of action at all. More than that, you're dealing with participants and not parties in whom legal cause of actions are vested. So you have this tremendous blank canvas with which you can work. And if you are creative as an advocate, and in particular, creative in assessing your client's desired outcomes because you understand their wider interests, you've got the possibility of working with a mediator in a way in which you would never be able to work under the constraints of the civil procedure rules.
Thank you, Andrew. Suzanne, could I ask you to comment on the role of safeguarding in hybrid mediation?
Yeah, safeguarding is crucial in any family mediation, whether the standard classic model or the hybrid model. And to that extent, it's important for the mediator to undertake effective safeguarding, effective intake sessions prior to the commencement of the mediation. So typically, the mediator would ask the clients to each separately complete a preliminary mediation form in advance of the intake session, and then have a 30-minute to 1 hour session with each of the clients separately, going through that form, considering whether there are any issues, any red flag issues that would militate against mediation, whether that be any domestic abuse, any substance abuse, any power imbalance that needs to be discussed. All of these things should be dealt with in detail in the intake sessions, and for the mediator and the client then to determine whether or not mediation is suitable in all of the circumstances. It may be, for example, that there has been domestic abuse, but it was some time ago, perhaps just one incident, and the parties both agree that mediation is still the way that they would like to go. The mediator accepts the role as mediator, but then sets out, for example, some ground rules. Perhaps the clients have staggered arrival and departure times if you're doing an in-person mediation. So effectively making sure that the mediation is safe for all concerned and there are no external issues that would preclude mediation taking place.
Thank you, Suzanne. Can I just turn to either Stephen or Andrew to comment on the intake process in civil and commercial and how that differs from what we've just heard from Suzanne?
Yes, I'll go first. We don't actually have intake sessions in that sense. You have normally a conversation, usually on the phone, but increasingly via Zoom, with the legal representatives, usually the solicitors, but I spoke to a barrister this morning, not usually with the clients, unless it's on Zoom, and then you do have them with the clients. You're not necessarily trying to identify the sometimes very sensitive type of issues which Suzanne described. You're just trying to get a feel for the experience of the clients in mediation, what their expectations of the process are, and what they're like as people. What should you as a mediator avoid saying? What's going to be a trigger, and that sort of thing. And you try and build up a bit of a rapport on a professional level with the lawyer.
I would agree with that, and more so. because I think the lawyer's role includes deciding whether or not to permit the client to mediate. Absent a mandatory process, I think it's important to discuss mediation with the client on every occasion that you're engaged in civil and commercial work, apart from anything else, because you've got to apply cost-benefit analysis to the work that you're doing anyway. And it may be that mediation is the quickest and cheapest process that's available to the client and should be tried irrespective of how strongly the client feels that he wants his position vindicated. The reality is, as we can see from changes in the CPR, that lawyers have got very little choice in having to engage in talking to the client about mediation anyway. And that's the point at which mediation comes in. I think it's a precursor to having the kind of discussion with the actual mediator or the potential mediator that Stephen was just talking about.
Karen, did I see your hand go up a moment ago?
No, I'm going to say chubby fingers like we had.
Right, okay. So moving on then to the change in the legal landscape. I mentioned in the introduction that there have been changes both on the civil front and the family front. And I wonder whether if we could briefly outline those. Andrew, if I can ask you first to just walk us through the key changes to the civil procedure rules.
The civil procedure rules changed on the 1st of October 2024 to reflect the freedom that the court now had after the decision in the Churchill case. For 20 years, we've been hampered by the Court of Appeal decision in Halsey, which without discussion or debate, accepted the absurd notion that mediation in some way interferes with the parties' Article 6 rights under the Human Rights Act. And the Court of Appeal were looking for a vehicle for many years to try and disabuse people of this notion. That came about as a result of which the CPR were amended. And you need to understand two things if you're working in the civil or commercial field. And that is simply this. The overriding objective in the civil procedure rules at paragraph 1.1f was amended so that the court now proactively promotes ADR. There is an obligation under the overriding objective in which the court will get involved. And to that extent, although it's called alternative dispute resolution, I simply don't see why the word alternative is fitting anymore. It's either appropriate dispute resolution or accelerated or whatever. The second big distinction is that at paragraph 1.42f, the court can now proactively help parties settle either the whole or part of the actions. And this means that the court is going to be actively engaged in pushing the parties towards settlement. It's really the sting in the tail that everybody has to watch, and that is the application of the rules in respect of costs. So there are two mechanisms that the court will use. The first is 44.3A2, which are concerned with reflecting in the cost order the parties' efforts to resolve disputes. And secondly, looking at part 44.11.2, which is concerned with the conduct of the lawyer or party representative. And in both of these cases, the starting point, which is one-way cost shifting, can be suspended at the discretion of the court. What that means, of course, is that firstly, the successful party in a case can be deprived of their costs for failing to mediate. That's certainly true by the existing authorities of people who simply refuse to engage in a request by the other side to mediate. Secondly, of course, the party can be awarded indemnity costs and penalty interest going the other way if it offered to mediate and the other side declined. And much more importantly, the lawyer can be ordered to pay the costs if by the lawyer's conduct, the party hadn't been properly advised in respect of mediation, or the lawyer hadn't properly responded to reasonable requests to mediate.
Thank you, Andrew. And I'm going to turn to Karen in just one second, but just to mention as well that because of the rather clumsy way in which the CPR in part are cut and pasted through to the family procedure rules, some of those CPR provisions apply with force when you're doing a family case with clean sheet costs. Karen, can you tell us about the changes in the family context?
Yeah, so there have been some pretty significant changes over the last 12 months, as Suzanne alluded to earlier this afternoon. I think we do run slightly behind the lead of the CPR rules still, in that mediation isn't quite at the position that it is within the civil arena, but we're fast catching up as a result of the changes, which became effective from the 29th of April 2024, when the definition of non-court dispute resolution at FPR 2.31b was widened to mean methods of resolving a dispute other than through the court process, including but not limited to mediation, arbitration, evaluation by a neutral third party, such as a private financial dispute resolution process, and collaborative law. Quite interestingly, lawyer negotiations, whether without prejudice or open, whilst encouraged, are not sufficient to form part of non-court dispute resolution within this new definition. And lawyers will be unable to self-certify that there's been some form of NCDR simply by engaging in negotiations with one another, unless they're within the collaborative process, which is a separate and distinct way of dealing with things. And I think that's quite important for lawyers, particularly those who don't have any training in the area of out-of-court dispute resolution, to bear in mind, because I think there's a real shift to moving cases out of the court system at every turn where appropriate. And of course, that necessarily is going to mean that the way in which we practice as lawyers is going to change, purely and largely in terms of environment and process, as opposed to exactly the service that we offer. So we start with the mediation information and assessment meeting. Authorised providers for that can be found on the FMC register. The number of exemptions has reduced, so it's quite difficult to get an exemption and not have to go through that gateway process. So it's really important that lawyers ensure that their clients are MIAM compliant. If they don't do so, you may be at risk of a costs order. It's not just a tick box exercise, and those undertaking a MIAM meeting will have to go through all forms of out-of-court dispute resolution and not just mediation. So it may be looking at things like a private FDR or an arbitration, not just mediation, as was previously assumed to be the case. We've now got the new form FM5, which requires you to explain why out-of-court options were not the right way of resolving outstanding disputes. You don't provide details of the confidential discussions that took place, but you will need to set out exactly what had happened. And you've got the new cost provision at FPR 28.3, where the court must have regard to any failure by a party without good reason to either attend a MIAM or to attend non-court dispute resolution as an option. And there are real risks of costs for failure to follow the protocol that is now in place. I think we are very poised to see a first costs order. I think there's going to be one bubbling away somewhere. And I think it's really important for practitioners to bear that in mind. The increased importance of Part 3 correspondence, which can be brought to the attention of the court in respect to case management and costs, is again something really important to bear in mind. And this really isn't lip service to the requirements. You really do need to ensure that out-of-court dispute resolution options are foremost in your mind when you're speaking to any client. and should be, as Andrew rightly said, it's not alternative anymore. It's really the go-to method of dispute resolution. In my view, a court application is fast becoming the alternative, not of choice, but of no choice if you find yourself in a very difficult situation where all other attempts to settle matters are doomed to failure. But that should be, in my view, very much the exception rather than the rule. So I would urge those of you on the webinar today to really familiarise yourselves from the family perspective with the changes to the family procedure rules, and the importance of fully understanding what your obligations are as an advisor to couples going through separation in either financial remedy proceedings or children proceedings, because it does apply to both.
Thank you, Karen. Just picking up on a subtle point of distinction between the family procedure rules and the civil procedure rules. I was on the family procedure rule committee that helped bring in brought in the FPR rules, so I know a little bit about the background to them. And you will find in the cost provision that the phrase that is used is an unreasonable refusal to attend at non-court dispute resolution, whereas in the civil context, it's an unreasonable refusal to engage with ADR. And the choice of attend in the family context is deliberate. There is concern that how do you measure engagement in a mediation? Are you, like was outlined at the outset, are you going to end up in a situation where mediators are being called to give evidence? And that is something which the family court has put a firm marker down that that's not to happen, and that there isn't to be a peering behind the curtain of privilege and confidentiality. And so the question in the family context is, was there an attendance at the non-court dispute resolution rather than trying to weigh the quality of the engagement? That's just a little train spotter point for those of you who were wondering. Right then, moving on to the role of the advocate in the mediation. Can I ask Andrew, first of all, please, to tell us what you think is the role of the lawyer in the run-up to and at the mediation?
Well, first of all, can I offer a confession, which Stephen might be pleased to hear? I've been pushing the concept of mediation advocacy since about 2005, but I'm free to admit that, of course, it's a misnomer, because advocacy has little place in mediation, and really the role of the lawyer is far more advisory than adversarial. The reason I wanted to run with the idea of mediation advocacy was simply to capture the attention of lawyers to the process and engage with lawyers so that they have some basic understanding of what it is they're supposed to be doing. I think that you know, the kind of audience we have today is far more sophisticated now, and of course things have moved on. But I would say this, that there are very separate, distinct functions that the lawyer has in the course of the mediation process, and they can be identified readily. The first I've already indicated. I think it's the lawyer's responsibility to decide, in circumstances where mediation is an option, whether or not to mediate. And that can be whether or not to engage in a particular form of ADR as opposed to early neutral evaluation or some other form of evaluative element, or whether simply to engage in a managed process of negotiation. I think that decision having been made, I think it's the lawyer's role to choose the mediator. And in part 2 of this webinar, we're going to spend a little bit of time looking at how to choose a mediator. Then I think the core element is to do with preparedness. Sometimes I think people flounder in the actual mediation room itself when they're engaged with the mediator, or when the mediator is engaged with their clients, and they don't quite know what it is they're supposed to be doing. And I would firmly suggest that party representatives earn their money before they arrive if they're doing their job properly. It's not simply a question of sorting out the practical preparation. Who is going to attend? What are they going to say? What is their participatory role? What do you as the advocate say to the mediator? How do you conduct the process? How do you represent the party in a moving environment? I don't think it's so much that at all. I think, first of all, you have to have regard to your case. Even if the mediation drifts off in a very different direction, you need to know the substance of your case. And I think you need to know the substance of the case on the other side. You have to know at least what both parties are saying. I think, therefore, you have to have some degree of assessment of the likely outcome of the case were it to have to proceed to trial. And I think that it's important that the legal representative has a very clear understanding of costs in respect of getting from where you are at the outset to what it's going to cost for your client to get to the end of a trial, if not the end of an appeal. That having been said, preparation is concerned with you having a clear understanding of your client's wider needs and interests, as well as their expectations and of the outcome. And focusing on outcome, I think, is vital. Clients aren't really interested in the process, but they are interested in the potential outcome. And they will arrive at the mediation with an expectation. Both you and the mediator in turn have got to manage that expectation as you go through the day. And a good deal of preparation is going to be concerned with effectively measuring outcomes. We in the trade, I suppose, call this the ATNAs, the best, understanding what is the best alternative to a negotiated agreement, or indeed the worst if there's going to be a range, and formulating your understanding of the client's plan B, the BATNA, is an essential role for the mediation advocate or advisor. You have to have an understanding of the client's wider interests, because you need to understand what is the balance between what is important to the client and what is important may go far beyond the simple nature of the dispute. Both you and the mediator may discover that, in fact, the dispute is not actually about what the legal cause of action would suggest it is, and that there are wider aspects which have to be catered for. And if those wider aspects have to be catered for, you need to understand the ramifications of that, because it may mean that you need people to come into the process that would not be apparent from the court process. And by the same token, the dynamics are such that the true decision maker may not in fact be your own client. The true decision maker may be somebody else who happens to be in the room who needs to participate. And you therefore need to understand that and understand how that works before you arrive on the day. One of the most important features of your role is to proactively engage with the mediator before the day itself. It's a really useful part of the process, that you can speak to somebody who is not the decision maker, but who is the process manager, because it means you can work out what it is that you need so far as your client is concerned, and where the mediation is likely to go. And you can give the mediator a steer at a very early stage about what is likely to be the important elements from your client's perspective, and indeed from your own perspective. And they may have nothing to do with the law, and they may have nothing to do with the case as pleaded. So I think that is an extremely important part of the function of the advocate. As an aside, I think it's very important, if the case would turn on expert evidence, for you to have regard to what experts you might need in the mediation, what you need them to do beforehand, and what role you think they can usefully provide in the course of the mediation itself, bearing in mind that this is not a process in which you're trying to prove a case. You are not adducing evidence or advancing evidence, but you will have regard as part of the negotiation to the strength of your case if you had to go beyond the mediation. Over the course of the day, I think the most vital thing for the advocate to do is to be able to discuss with your client the true value of the offers that are coming from the other side and compare them with the likely outcome if you had to remain in litigation. You do a cost-benefit analysis if it's purely a question of money, but what you're really trying to do is to measure risk. And that measurement is going to change over the course of the day, because you will have the opportunity of seeing the other side, seeing the other side's lawyer, meeting the other side, receiving information that you may not have, and having a clearer understanding of the wider picture between you. And this may mean that your evaluation of the BATNA changes over the course of the day. It's a movable feast. And at the very end, you're not going to be the decision maker, but you're going to be having a significant role in deciding whether the client's apprehension of an offer is going to be favorable or not. And finally, I think very clearly your role as the lawyer is to help draft the settlement agreement together with the other side. That's that the mediator has no role to play in drafting the settlement agreement in civil commercial work. It's something that's got to be workable, it's got to be lawful, it's got to be practical. It should really follow the SMART model so that it's time-bound as well as measurable. And you've got to be confident as the lawyer that the draft settlement agreement is exactly what has been agreed. And very often, and I'm sure Stephen will confirm this, the mediator can get to the parties to agree quite early on, and it still takes the lawyers another few hours to sit down and work through the agreement to their satisfaction. So that is fundamental in respect of your role as the party representative. Remember that it's not simply the party. You, the lawyer, are also marshalling the participants who are going to make a contribution in respect of your side.
Thank you, Andrew. I wonder whether either of our family lawyers want to make any observations about the role of the advocate in the hybrid context.
Yeah, in the hybrid context, quite often the lawyers are more fully involved, and many of the same points that Andrew's making would apply. So preparation, considering managing the client's expectations, considering potential outcomes, and potentially helping with the drafting. But I think there are some points that are unique to the hybrid model. One would be attending a preliminary meeting. So the lawyers attending an initial meeting with the mediator to talk through what the areas of dispute are, and potentially agreeing with the mediator what documentation to bring to the mediation. So could be preparing an agreed bundle. Obviously supporting the process throughout. In a financial mediation, I think our expectation would be that the lawyers have signed off on the financial disclosure documentation. So the Form E, because the Form E and that financial disclosure is open disclosure and could be used in a court process if the mediation fails. So it's really important that the lawyers have signed off, and it's not just the clients submitting the financial disclosure. Typically, we would expect the lawyers to attend the mediation sessions in relation to potential option development. and specifically if there's caucusing. So if there are going to be shuttle mediation sessions, if there are going to be confidences held, then we would expect the lawyers to attend those sessions. And the lawyers would be involved in assisting the process as it develops, and sometimes drafting the settlement documents on the basis that they've been there in the mediation. They've probably given legal advice during the course of the mediation to their respective clients, and would be in a good position to cost effectively prepare the documents. It's actually a really cost effective and good way of mediating, because the lawyers are involved and are on hand to provide relevant legal advice throughout the process. Karen, I don't know if you want to add anything.
I just think I would add that I agree with Andrew that the role of the lawyer is a supportive one, and that support begins before the mediation itself actually starts, in providing the advice that enables the clients to participate from an informed position in the negotiation. I think that as we see more and more cases that would have litigated going into the process of hybrid mediation, which I think is happening more and more often, and that lawyer support being so relevant in those circumstances, means that the lawyer role and the involvement of counsel, because I think counsel are going to are already starting to attend hybrid mediations more, and I think that's only going to increase, and it will be a bit of a shift in counsel's role in that respect. But I think one of the benefits of the lawyers being present in a family environment is that, one, they can create an open agreement, having confirmed that they've given advice, so that proposals advanced within the mediation can become instantly binding, which I think is very beneficial, particularly in high conflict cases. And also, Andrew mentioned cost management and how important that is. I think that becomes even more so in the family context, because of course the costs are coming out of one family pot rather than two separate participants. And I think that's a particular importance in the family environment. But otherwise, I support the comments made thus far.
Very briefly, Suzanne, any observations about the lawyer's relationship with the mediator?
Well, the mediator is obviously an independent, neutral facilitator and must maintain their impartiality throughout. Sometimes, often, the mediator will know the lawyers very, very well, but it's really important that the clients don't have a sense that anything is being done behind their backs. So making sure that the mediator really controls the process with the support of the lawyers. It may be that some of the meetings, the mediations, the lawyers won't be present, and it's up to the mediator to choreograph that and to make sure that the clients are fully engaged and involved in the process, and asking them their views about the attendance or otherwise of the lawyers as the process evolves. I don't know if you, again, Karen, if you want to add anything there.
I think that the professionals meeting is really, really valuable, because it follows on looking at the civil side, that ability for the lawyers to engage with the mediator at a really early stage, identify the issues without the clients being present. And I think that really supports the process. And I think that one of the good things about the changes in the family procedure rules is that it's compelling those lawyers who were nervous to dip their toe in the mediation water in the family environment to have to embrace these processes. And I think once you've tried resolving something through a hybrid mediation, lawyer supported, you can really see the benefits of it, and it's going to have a snowball effect with repetitious work resulting as an immediate and direct consequence. And I think that as mediators, our engagement with the family lawyers at that early stage enables us to explain the process and dispel the myths, and that can only be beneficial.
Rhys, can I just add to that?
Sure.
Sort of an overarching principle, which is that advocacy as such is the subject of training by the professional bodies. And we're trained in the orthodoxy of advocacy training presupposes that you're working in a contentious and therefore competitive environment. And advocacy is not trained as a collaborative process. And we now face a situation where the vehicle that we are using to benefit our clients has got at some point to be a collaborative process, if not a cooperative process. And psychologically, lawyers who've never been trained in anything other than an adversarial process find it very difficult. I don't know whether in family work there is now formal training in collaborative working, but there's certainly no formal training at the bar in collaborative working. And I'm very keen that people who are looking at these this podcast, this webcast, have a clear understanding that they have to find a way of moving in the course of the mediation process from effectively being contentious to becoming in some form collaborative. They're not going to want to let go of their clients' good points, which they can advance as an advocate, but they need to understand how to make use of them within the mediation. I'm not suggesting people waste their good points. I'm suggesting they learn how best to place them so that the mediation process works.
Thank you, Andrew. Suzanne, is that a hand you want to chip in on?
Yes, I just want to say there is training on working collaboratively in the family context. So there's actual collaborative practice training, but also lots of other training via resolution. And just a quick shout out to Karen and my hybrid mediation training, which is available to people who are mediators to train as hybrid mediators. Next one happening on the 3rd and 4th of November. Quick shout out.
Thank you. Right, we've got a couple of minutes left. And we've had a question in. It's a double-hatted question, really. During family proceedings, where there are allegations of domestic abuse made by one party against the other, would a MIAM, that's the first hat, or NCDR be exempted? Do either of the family lawyers want to take that one on?
I've got my old hand up. I'm happy for Karen to answer it.
So a situation where there's domestic violence is the one remaining exemption for a MIAM. But what I would say is I don't think that the existence of domestic abuse should be something which prevents the mediation process going ahead. Suzanne's talked about the safeguarding and the measures that as mediators we're able to put in place. And I think in terms of physical safeguarding, well, mediators are the only family law professionals who have real training in safeguarding, which I think is a really important point to stress. And secondly, the measures that we are able to put in place are far more bespoke and safe than anything that the court can manage with a screen that might or might not go up. And what happens when somebody actually leaves the court environment. Also, the sheer delay of the court system, in my view, perpetuates abuse in itself. I've settled a number of cases in mediation where there have been bail conditions and injunctions in place which have been lifted to allow the mediation to go ahead with the couple not coming face to face, because those issues need to be resolved somewhere. And it will take a great deal to convince me that the court is the right place to do it. I don't see the court as being a place of safety at all, far from it. I think we can create a much safer environment within our private practices.
Okay, we're almost out of time. Suzanne, did you want a final word there?
Just really quickly to say that I too have had a couple of cases referred by the court recently into mediation where there are injunctions in place. We've put the relevant safeguarding points forward and that's been accepted and the mediation has taken place. And secondly, there is a lot of safeguarding training if anybody wants to train as an arbitrator, there's a huge amount of safeguarding training.
Right, well, it's 1 o'clock, so time's up, folks. Can I just thank our panel for the insights and contributions they've made this afternoon. Certainly, I found it very interesting, and I look forward to hopefully seeing you all again on the 10th of June at 1 o'clock, when we can go through part 2 and the more granular aspects and practical aspects of running a mediation. Good afternoon, everyone.